The Court of Appeals is now in session.
All right, good morning. Welcome to the Utah Court of Appeals as we continue to sit in virtual session. I'm Judge Ryan Harris, and today with me are Judges Michelle Christensen-Forster and Judge David Mortensen. We're happy to be with you today to hear the case of Duffin versus Duffin. It's case number 202000361. Can I have the attorneys for the parties enter their appearances for the record, please, starting with counsel for James Duffin.
This is Bo Olson on behalf of James Duffin, Your Honor.
Morning, Mr. Olson. Thanks for being here. And for Brandy Duffin.
Jake Hinkins here on behalf of Brandy Duffin, Your Honor. Good morning.
Good morning to you as well, Mr. Hinkins. I'm guessing that both of you have been with us once or twice, or with some court once or twice in the virtual era. So I'm going to dispense with most of the instructions we've been giving. Just trying to, even more important than ever, to not talk over each other and watch for sort of nonverbal cues from us. And we might want to jump in and ask a question. Other than that, it's probably pretty familiar to you by now. Are there any questions or concerns about the way things are going to proceed over the next half hour or so?
Not from me, Your Honor.
Nothing from me, Your Honor.
Okay, and we're here on cross appeals, so it's 20 minutes aside, and it looks like the clock says 15. So does that mean that 5 minutes have been reserved for rebuttal? Is that right?
That is correct, Your Honor.
Okay, well, if there aren't any other questions or concerns, Mr. Hinkins, we'll turn the time over to you, and we'll look forward to hearing your argument.
Thank you, Your Honor. I appreciate that. May it please the court, counsel, I appreciate the opportunity to be here this morning and to be able to represent Brandy Duffin. We're here today to talk about what really is the quintessential asset in most divorce cases. And I'd like to start with a saying that I think has always been true, because when something looks like a duck and it quacks like a duck and it flies like a duck, it's a duck. And in this case, you're going to hear from the other side that this duck is not really a duck, but it's a fox or it's something different. And that's just not the case. What we have before us, Your Honor, is a situation where these parties were married. It was a relatively short-term marriage, but as the marriage started in early 2016, the parties started looking for a home. And in April of 2016, the parties entered into a REPSI. Both parties, Brandy Duffin and her husband, Jimmy Duffin, entered into this REPSI with Ivory Homes to build a home. And what you're going to see through the course of this is all of the documentation. This is very much like the Finlayson case, Your Honors, because what we have is all of the documentary evidence is going to suggest that this home was owned by these parties. We have a REPSI that was signed by both parties. The parties worked together and built this home. At no time was Mr. Marlowe Duffin, and I apologize, I'm going to state, I guess, early on, I'll probably be using first names in this, primarily not to be flippant, but only because we have 4 Mr. James Marlowe Duffins. And so in order to distinguish those, I think it's important. And so when I'm talking about Jimmy Duffin, that is my client's ex-husband. And when I'm talking about Marlowe Duffin, I'm talking about his father. Mr. Jim Duffin was the grandfather of my client's spouse. And then the parties have a younger child, which I don't intend to talk about at all. But the reason that distinction is important is these parties went into this home process expecting to buy this home for themselves. There was no discussion between Marlowe or anyone else. All the testimony at trial that came out was that, at least from Brandy Duffin's point of view, this was always going to be their marital home. And
they were planning on financing it how?
Yeah, so Brandy was working. She was a nurse working at that time. She was pre-qualified. That's another piece of evidence that came in this case, the pre-qualification letter.
But wasn't she only working part-time on 1 or 2 days a week?
She eventually did only start working part-time, and that happened in the course of this case because at the time, she had a young child and they were anticipating having another child. And so that is correct, but she was pre-qualified to be able, from the amount of money that Marlowe Duffin was planning on providing them as a down payment, she was able to pre-qualify for this home, and that pre-qualification letter came in as evidence. That was not disputed, that she would be able to qualify for the home. And it was only at the last minute that Marlowe Duffin then came in and paid off the entire home. That was never anticipated. Yes, Your Honor.
Wasn't that pre-qualification based on Marlo Duffin's bank account information and not Brandy and Jimmy's?
Only to the extent of the initial down payment. That there was nothing about that bank account that was assessed for anything other than for the down payment, because that was the plan. There always was going to be some amount of money that came from Marlo Duffin. The anticipation from the parties, at least early on in that process, was that he was going to provide the down payment, and the parties then were going to be able to qualify for the rest of the home and be able to pay for that home. And
provide down payment as a gift or provide down payment as a loan?
Yeah, so that's a great question, Your Honor, because early on, and this ends up looking a lot like the Finlayson case in some ways, because my client always believed that that was going to be a gift. That's what had been discussed with her. And then behind closed doors, evidently, we see in this case that there were these loan documents going back and forth. And my client was completely unaware of that. In fact, my client was completely unaware of that until only a few months before trial, that those documents ever existed, that there was anything that would be able to substantiate the idea that this would ever be some sort of a loan. And so that, yeah, Your Honor.
The question of whether Marlo has an interest in this house and whether that interest is fee simple or some sort of security interest as a lender, that was what was being decided in the other case, right? Do I understand that right?
That's absolutely correct, Your Honor. And I think that's important because in the Finlayson case, we have that specific language where it says, even so absent some kind of intervention, a divorce action deals only with the rights as between parties to the marriage, does not operate to assert the rights of a third party. And that's exactly what we had here. And I can understand in this case, part of the issue is we have a home that obviously was worth a lot of money and then appreciated significantly. But we can't get hung up on that. If we do, that becomes a horribly slippery slope, because what we're looking at really is we're looking at a situation where these parties come in, they own the home. There's no question that legally Jimmy Duffin is the only person who had fee simple absolute and had right and possession of that home from the very get-go of this. And as that progressed, he eventually adds a year later. So let me give the timeline just because I think that's really important. So on February 9th, 2017, the initial deed is entered, and that is only entered for Jimmy Duffin. Obviously, we're in the course of the marriage. This property comes in the course of the marriage. It absolutely is a marital asset. There's no way that this could be separate property. It's not pre-marriage. It's certainly not a gift. There was no evidence that this could ever be a gift. In fact, Jimmy Duffin filed for and got summary judgment that this wasn't a gift. And so there's just no way for this to be a gift. It's obviously not an inheritance. That was never argued. And so what we have is truly the quintessential marital asset that comes into this party, and it's only owned by Jimmy Duffin. Then, over a year later, February 22nd, 2018, the parties are having marital difficulties. Jimmy then goes and he adds his dad onto title. The reason that those dates are also important is as you look back at these emails that are going back and forth that were subsequently disclosed just before trial, Jimmy is evidencing this idea of a loan, which in some ways makes sense. This really is a situation where the parties own the home. And if Marlo had a loan, great, Marlo had a loan. Certainly the evidence suggests that there was this promissory note that Jimmy Duffin executed, sent to his dad. There's no evidence coming back that Marlo ever disputed that was a loan. Yes, Your Honor.
If we were to reverse here, would we do so also allowing the trial court to revisit the issue of who's responsible for the loan debt?
No, Your Honor, because that was addressed already. What we would be looking for is a reverse and remand with instructions very similar to Finlayson. The court entered this as a marital property, and the parties then equally divide that. And the reason, Your Honor, to jump to your question, that has already been dealt with. We filed a motion in limine. The parties did not. Mr. Duffin chose not to file anything to do with this loan. He filled out his financial declaration. He listed the house as an asset. He didn't put anything to do with a loan. But what he did do then is just a couple of months before trial, he provided these two different loan documents.
Let me just interrupt you for a second, because the court makes the specific provision in the final decree or findings of fact that the debt, if it exists, is going to be Jimmy's problem. I'm using the terms that you've identified to identify the parties. But that seems to be predicated, at least in part, upon the determination that the house is not a marital asset. If those are intertwined, why can't they be revisited?
So because it was dealt with, so although it exists in the decree, it was already dealt with previous to the trial in a motion in limine that we had filed. And what the court found was the direct language, I believe, is if this court or any court in the future finds that this was a marital debt, then it is only, or finds that this was a loan, that this is only Jimmy's loan, because he sat on his decision to not provide this with his 26.1 disclosures, as we believed that he had an obligation to do. And he decided at that point that he was going to essentially keep this from our side. And so what the judge determined was, because he did that, that debt would solely be his, pursuant really to the same idea that when somebody doesn't disclose an asset, the other party then may get that. And so in this case, with somebody, in this case, Mr. Duffin, didn't disclose properly that debt, and we had no opportunity then in the course of the case for over a year and a half to do any discovery or anything like that on that debt, he then gets the full obligation for that debt. Yes, Your Honor.
I want to come back to something you said a minute ago about how if we were to reverse, what you're asking us to do is declare that this house is a marital asset. And I guess I didn't understand you to be going that far. It seems like what you're asking us to do, given the presence of this other litigation, and I'm not sure exactly what the status of it is now, but it seems like the most you can ask for in this case is a determination that whatever interest Jimmy and Brandy have is a marital asset, because the other court may determine that everything, the house, is owned by Marlowe, right? And if that's the case, then these folks, this marital union, had no interest at all, right? Do I misunderstand?
No, you don't, Your Honor. That's a fair clarification. So and let me take that a step back, because the reason that I'm saying the way that I am is, at the outset, only Jimmy's name was on the deed. And that's why it truly was a marital asset from the get-go. By the time we proceed to trial, Marlowe's name is on the deed. So there is certainly a dispute, and Marlowe would have an interest, although he didn't intervene. He has some interest legally on that title because he's listed there as joint tenants with rights of survivorship. So that will all get settled in the other case with Judge Stone as to whether that was either a fraudulent transfer or whether the two of them have this defeasible interest. And so really what we are asking the court to do is to determine that there is a marital interest in the home. That to the extent there's a marital interest, and to the extent there's an interest that Jimmy or that either one of these parties might have, that interest is marital. I don't think you're asking us to determine that there is such an interest in this home yet, because Judge Stone might determine that it's all owned by Marlowe, right? That's correct, Your Honor, and that's a good clarification. And
over in Judge Stone's case, it seems like there's three possibilities that he could come to. Number one, everything is owned by Marlowe, and neither Jimmy nor Brandy owns anything having to do with this house. Number two, Marlowe has some sort of security interest up to the amount of his loan and with some sort of provision for interest. And number three, Marlowe has nothing, and everything having to do with the house has to do with this union, right? Those are the three things Judge Stone could decide, right?
That's a fair statement, Your Honor, and that's correct.
Okay, and we need to let Judge Stone have the room to decide which one of those three things it is. So I think as far as this case can go is to determine that any interest that this marital union had is a marital interest rather than something else, right?
And that's correct, Your Honor. And that's important because as the court sees that in the specific language in the findings of fact and in the decree, the court went so far as to say that it didn't know what interest Jimmy had in the home, but whatever it wasn't a marital interest. And so we are asking that this court reverse that decision, because we believe that whatever interest he had absolutely was a marital interest, and therefore then would be equitably divided with my client, Brandy Duffin. Is that a fair clarification, Your Honor?
Yes, that helps. Thank you.
Great. Looking back at a couple of the other things, this is a situation, and we obviously have talked about Dunn, and I think the distinguishing factors there with Dunn really being a situation where we're dealing with contributions and things in a corporation. There are a lot of similarities in some ways, and in this case, let me talk about a couple of those. In this situation, the parties, there's no dispute that the parties put down the initial down payment, the $1,000 down payment that held the home, and then they built that home through from that point forward. There were also contributions to the home. The parties worked and cleaned. The danger I think that we run into if we're trying to determine some sort of value, and the issue that the court ran into was this idea of de minimis value from a fence, cement pad, basketball hoop, outdoor furniture, swing set, radon pipe, curbing, ring doorbell, security system, and saying, hey, all those things happened, and these parties then provided that information, provided that work, but that's de minimis in comparison to a $450,000 home. When in reality, that then puts a horrible burden on anybody who is a homemaker, because they're there taking care of the home. Their responsibilities are to ensure that the upkeep and the care for the home, and it shouldn't rely simply on the idea that there's a monetary value attached to it. Thank you.
Thank you, Mr. Hinkins. We'll look forward to hearing from you again on rebuttal. Mr. Olson, the virtual podium is now yours.
Thank you, Your Honors. There's just a few clarifications that I'd like to make. Number one, if we look at the record closely, it appears as if they were only approved because they did use their dad's bank account records. They weren't approved based on their own merits there. Number two, the summary judgment that my client filed was for a judgment that the money that was given to the parties was not a gift jointly. And so it was never decided if it was a gift to my client, Mr. Duffin. It was just that it wasn't a gift jointly to the marriage. There's a few things that I'd like to point out too as I get into my argument, Your Honor. I think it's important for us to remember where we're at here. Number one, Judge Bates has broad discretion on how he wants to equitably divide property. Number two, his division has a presumption of validity. Number three, it's upheld unless there's a clear and prejudicial error that's demonstrated. And in order to show that there's been an abuse of discretion, it has to be that there's no reasonable basis for that decision. And so as we go through his order and we go through the trial, he relies on Dunn a lot. And he goes through it and he thinks about it and he decides that based on Dunn, he can hold that this is not marital property. And if we look at the Dunn case, one of the important things that we have to note is that the Court of Appeals in that case noted that the trial court only mentioned that the net tangible assets are not marital assets and not subject to division. That's the only conclusory statement that they made. They gave no other indication on why they believed that it wasn't a marital asset. Here, Judge Bates does something much different than what the trial court did and done. Number one, I think the real only question that the Court of Appeals has to ask is was there a reasonable basis for the decision that Judge Bates made to hold that the West Jordan property was not marital property? And here's Judge Bates' justification for that. Number one, my client's father paid 100% of the cost for that property. Number two, my client, James, was the only one on the deed. Number three, they only lived in the house for a short duration, and the marriage itself was only for a short duration. Now, to contrast a little bit, yes, Your Honor.
Well, I understand those facts, but we also have repeated statements from our court that says the marital property, and the quote is, ordinarily includes all property acquired during a marriage, and then it explains whenever obtained and from whatever source derived. So explain to me how the source of money, whether it's from a bank or a dad acting somewhat like a bank, or even if it's a gift, how that, well, I guess if it's a designated gift, that might be different, but how that changes or fits in with that precedent that we're dealing with?
I think that's a good question. Number one, I think you use the words ordinarily, and that's from the Dahl case. And it is ordinarily marital property. But I think what Judge Bates found is that there was extenuating circumstances here because there really was nothing, as Judge Bates said, that the marriage did to contribute or maintain this property. If it were from the bank, Your Honor, then they would have to pay a mortgage payment. Those mortgage payments were never made here because there wasn't any sort of money going back and forth between my client and his father. Number two, if we look at the record closely, there was I believe my client said in his testimony that this.
Well, so a bank doesn't have to foreclose, and it seems to be the argument now that, or the factual development after the fact seems to be that either contemporaneous with or after the fact, there was some sort of loan here. They're not making payments on that loan either, are they?
There's been no payments, and I was going to get to that point a little bit, because if we look at my client's testimony, he said that the situation was fluid. And what that means is a lot of times when you have a close relationship with somebody, like he did in this case, his testimony was that if he exercised the option to purchase that property, then that would have become a loan and they would have paid it back. He never exercised that because he never graduated from school and could never afford it. So what I think is important to note is also his father's deposition on when he was asked, why do you believe this property is yours? He replied, because I paid for it. There had been no agreement. There had been no finalization that my client was going to begin paying his father back because they never had an agreement that it was his yet. I recognize that he was on the title, but there was an agreement between his dad and himself that once he graduated and had the income to pay for it, that's when he'd purchase the property and start paying his father back, and he never got to that point. Does that answer your question, Your Honor?
I understand your position, sure.
Thank you. So just hitting on a few more things, I think it's important to note that one of the most important things that Judge Bates said in his ruling is at the very end. I mean, when he said, if we were to deem this a marital property, then that would create an inequitable benefit or windfall to Ms. Duffin. And so, like we know from the case law, he has the ability to make equitable distributions of whatever property that is and wherever source it's derived and wherever it comes from. And what he decided was that it would be inequitable to be able to have her have some sort of windfall of a $450,000 property. So whether, yes, John?
Yeah, help me understand that, because let's say Judge Stone determines, may or may not occur, but let's say Judge Stone determines that Marlo has a loan up to $430,000 in principal plus some sort of reasonable rate of interest. I don't know what this home is worth now, but wouldn't the marital interest be limited at that point to whatever appreciation is inherent in the home in excess of whatever the mortgage term is?
So I think that's what the equity would be in the home. And I think they'd have to go back to the decree of divorce. I don't think that she'd be entitled to any sort of equity from the appreciation that it is now. I think that would go back to the date of the finalization of the divorce.
Right, and that's my point. So what windfall are we talking about here, right? I mean, the judge seemed concerned that Brandy would get some kind of windfall, but as I do the math here, is if we're just talking about the appreciation during the time of the marriage, this is a pretty short marriage. How much appreciation occurred there, and assuming that Marlo has some sort of security interest in the home, how much is Brandy really going to get out of this? I mean, how big is this windfall? Help me understand that.
So I think that's a good question, and I think we have to look at the context of the litigation. As Mr. Hinkins discussed a little bit, there was a motion in limine that was granted on his client's behalf, where my client was going to pay for, if there was a loan, that he'd be responsible for 100% of the loan. And so what Mr. Hinkins, I believe, was arguing at trial is so that she should be entitled to 1/2 of the total value of the property, not just the equity, since my client was supposed to be the one who was 100% responsible for the loan. So the way I understand what Judge Bates was saying was that there's no way that it's equitable for her, if that's what their argument was, that she should get 1/2 of the total value of the property and not 1/2 of the equity of the property after the loan's considered.
Yeah, I guess I don't understand how Brandy has any claim to 1/2 of the total value of the property, assuming that Marlo has a security interest. And I get that Judge Stone has to make that decision, and Judge Stone, I guess, conceivably could find that Marlo has no interest whatsoever in the property, and then maybe we're talking about a larger amount of money here. But the equity in this home, at least the equity that was generated during the marriage is not very much money, is it? Am I missing this?
No, I mean, I don't think the real estate market was the way it was now, right? I don't think the appreciation was going up 10% a year, and they'd only been living in the house by the time the decree was signed for about 2 years. So I don't think we're talking about a huge amount of equity that would possibly be available. Just one more thing that I think is important to note, and then I'm going to, if you don't have any more questions, I'm going to briefly switch gears to our cross appeal. One of the things that's important to note is what Judge Bates said, is that the marriage didn't do anything to support this property. They didn't do anything to maintain this property. They were basically living there rent free. They didn't pay taxes. They didn't pay anything. And so for it to convert to marital property, I think goes more to his credit that it's not equitable. And part of it is what Your Honor Harris is talking about, is maybe they need to decide that in the quiet title action before Judge Stone to see if there's anything valuable, anything that they can, any value that can be transferred there, which we would argue that there is not. But that's another case, Your Honor. So I know I'm running short on time, but I just want to point out one thing on the Finlayson case. It's actually not, it's not apples to apples with this case. Number one, it was a 26-year marriage and it was a short duration. Number two, they were both on the deed, just not one party on the deed, and they were on that deed for 12 years. Number three, they paid the real estate taxes on that property each year, and they maintained it by weeding it and doing things like that to make sure that the property was properly maintained. The parties in this case never did such thing. So in respect to Ms. Duffin's appeal, does the court have any further questions for me, or am I good to move on to mine? Okay. Our cross appeal is fairly short, Your Honor. Basically what happened, as you know, is under Utah Code Annotated 30-3-3, attorney's fees can be awarded at the discretion of the judge. I recognize that, but there also has to be evidence to support, number one, the financial need of the requesting party, and number two, that the payor spouse actually has the ability to pay the attorney's fees, and number three, that there's a reasonableness in those attorney's fees. And so if you look at the evidence that was provided at the trial court, we have, number one, Ms. Duffin had a need of $2,300. She then had income of $1,900 or so. She then received about $1,067 in child support. So just doing simple math there, she had an excess of $680. But even to take it one step further, which I think is most important for our appeal, is we had a finding by Judge Bates that my client's income was $8,145.91. Sorry, that my client had expenses of $8,145.91. He then found that my client had an income of $8,146 per month. If you do the math, that means my client had the ability to pay of 50 cents. There's no way, based on the evidence that was provided, and there was no scrutiny into the expenses of my client, the income of my client, that he had the ability to pay attorney's fees. And if he didn't have the ability to pay attorney's fees based on Judge Bates' own findings and the evidence before him, it's against the statutes and the case law for Judge Bates to order my client to pay attorney's fees. And I think it's interesting to know that on the record 1995, Judge Bates specifically stated that neither of these parties were self-sufficient, that they were both relying on family members and gifts to be able to help pay their day-to-day expenses.
So did you raise this particular argument in your post-trial motion about attorney's fees?
So I was not counsel at the time, but when I reviewed it, if you look at the record and it's 2522, his objection specifically stated that Judge Bates did not follow Utah Code Annotated 30-3-3, and that they reiterated that he did not have the ability to pay. Now, when the court came down with its decision, they reiterated that he did have the ability to pay, but they didn't give any instruction on how that was the case or why it was applicable. So
did they ever attack the adequacy of the findings at any point below?
I think in vague terms, but they never filed a specific motion to attack the findings. They did not, Your Honor. And so I know where you're going with that. And so I think if you find, I believe that it was properly preserved. I think that it was preserved at the trial court. If you remember, they specifically asked to file a motion regarding attorney's fees and why they thought it was inapplicable. And Judge Bates said, when we get to that point, I'll ask you if I need it. But if I feel like I'm comfortable because I know this statute very well, I won't ask for it. And then they again brought it up at trial, and he said, I'm good on attorney's fees. I don't need any more supplemental briefing on it. So I think it's practitioners are in a hard situation because we have to be respectful to the court. And when a judge says that they know the issue and they don't need any more briefing on it, we kind of accept that. But in this particular case, it appears that Judge Bates did not understand the law in that case. Yes, Your Honor.
I totally get that. I think you're 100% correct. If the trial court says I'm good and I don't want to hear from you, then it's a brave lawyer who says, no, Your Honor, I'm going to make you listen to what I have to say. On the other hand, once the court issues its findings, it seems like there's a space there where you can then say to the judge, a Rule 59 motion or whatever means you want to try. Number one, judge, you got it wrong on the law, and or alternatively, your factual findings don't support the conclusion that you're making. In other words, give the judge an opportunity, despite the judge's statement that the judge understands the law, to get it right in your view. Shouldn't you have to do that?
And I think that's what the objection was, because we weren't disputing the factual findings. We agreed that my client's expenses were $8,900 a month or whatever they were. And we agreed that that's the amount of money that he was getting. But the objection was specific that he was wrong on the law, that he was conflating 30-3-3 and Rule 52. And they were specific on that. And so I do think it was preserved there. I don't have any doubt that Judge Bates knew what the argument was, because he again reiterated in his decision that says, your client has the ability to pay, and that's just simply not the case, and that wasn't the evidence before him. My client can't have the ability to pay attorney's fees if his expenses are the same as his income, and especially if they weren't reduced by the court.
The income just came from his father, right? That wasn't like a pay stub number that Judge Bates was looking at, right?
That's correct, and that's another issue, I believe, is what this attorney's fee award essentially did was make his father pay the attorney's fees.
Well, right. I mean, so couldn't Judge Bates reasonably find that, hey, if your expenses rose a little bit more, then you could just ask for a little bit more? I mean, your expenses kind of float with your income, kind of floats with your expenses in this situation, right?
Well, that's maybe an argument, and this is maybe outside the appeal, but the person who was funding the lifestyle has now passed away, and so that's not there. So, and he passed away the day after Judge Bates came down with his oral ruling. So I don't think there's anything in the evidence to suggest that those payments would continue to come to pay for attorney's fees and things like that. What really happened is they have a special needs child, and they were both doing whatever they could to take care of the child. And due to the stress of the litigation, my client took a step back from schooling and needed some financial help. So my time is up, so I'll reserve. I think I probably have 3 minutes left. And thank you for your time, Your Honors.
Thank you, Mr. Olson. Mr. Hinkins, back to you.
Perfect. Let me start where Mr. Olson left off, because I think it's really important on this. Because if you look at the initial financial declaration that was filed as compared to the next financial declaration, what happened in this case is that went up by a couple of $1,000s. And so certainly Judge Bates could have looked at that and said, hey, what's happening is he's getting exactly enough money to match everything that he's receiving, and all of his expenses are being paid perfectly. And so if you look back, though, there was never any finding that anybody other than Marlo Duffin was funding all of his lifestyle, funding all of his expenses. And certainly he continued to do that throughout the course of this case to the exact within 9 cents, if the court looks at the financial declaration of what all of his expenses were. If the court looks back at let me start here, I guess, just with the attorney fees. It was not preserved. There was no objection as to whether attorney fees could be allowed or could not be allowed. The only objections that were raised in what was actually filed were as to certain expenses and certain costs that were determined, by previous counsel that they didn't believe were appropriate. There was no preservation in this case. That what they had an obligation to do was actually object, say, we don't believe that the attorney fees are warranted. They did not do that. We also believe that they didn't actually challenge the findings. They had an opportunity to challenge the findings. And while I can appreciate what Mr. Olson is saying, that's always the burden. If you're going to plan on bringing something back on appeal, you have to make sure that that's preserved properly, which includes then challenging these findings. As we lay out in in our appellate response, or our response to their briefing, I think it's pretty clear that in a situation where the facts actually do substantiate the award, these folks are not trying to challenge the idea that there aren't facts that substantiate the award. They absolutely substantiate the award. Mr. Duffin was making 4 times more than my client. The amount of attorney fees that she had to incur were over 2 years worth of her entire not savings, but her entire income. This was substantial. Implicit in that ruling is the idea that that Judge Bates, frankly, just like Judge Harris was suggesting, probably looked at this and said, everything that has ever happened in this case, all of the expenses that have been needed by Jimmy Duffin have been paid for by his father every single time to the penny. Nothing was lacking. And so certainly there are facts to support the idea that Brandy Duffin, she definitely had a need. That's laid out in the court's ruling in the findings of fact. And then also it's clear that he lays out the fact that it's certainly, I think it's explicit, but it's definitely implicit that he has the ability to pay, because he's suggesting that he has 4 times the income as Brandy Duffin and always has had the ability to pay for everything that he's ever incurred. Let me go back, if I can, quickly to a couple of points on our briefing. It was never argued, and there is no evidence in the record that the amount of money that was paid by Marlowe was ever a gift. As Judge Mortensen correctly asserted here, if we go down this slippery slope, then we're looking at situations trying to determine who's providing funding in every marital asset case. That can't be the law in the state of Utah. In almost every case, the parties are not coming in and paying cash for something. There's a bank, and in this case, there's a loan. And Brandy Duffin knew nothing about that loan, but certainly that's not our problem. They could have provided that information. They chose not to, because they sat on their laurels and withheld that. Judge Bates ruled the way that he did in the motion in limine. That ends up all being Jimmy Duffin's responsibility. In trying to create an equitable situation, Judge Bates is looking at this from the aspect that if we give half of this, value of this property to Brandy Duffin, we're going to create this inequity. But what he really ends up doing is creating a horrible inequity that only favors Jimmy then. That's not what the law is set up to do. These parties, they take this at their own risk and behavior, and that's what happened here. Jimmy Duffin came in, these parties, this was their quintessential marital asset. They came in, they bought the home together, everything was in their names right up until the time that they're in the middle of having marital problems, and then they add Marlowe Duffin to this. So then we have this legal dispute, but outside of that, there's no legal issue that would challenge the ownership. Yes, Judge Harris.
Can you address the question I put to Mr. Olson about the size of the interest that you think you're entitled to? You just mentioned a minute ago that you think there might be a loan, at least, in favor of Marlowe in this home. If that's true, what is the extent of the interest that you think that the marital union has? What is the extent of the marital interest? Is it just the appreciation of the home over and above that loan during the time of the marriage, or is it something else?
No, it is something else. And the way that we value properties in marital cases is we look at the actual value of the property. Then if there's a marital debt associated with that, that decreases the value of that property. But what we found here is that loan is only Jimmy Duffin's problem. It is not a marital debt. And what ends up happening then is the total value of that property has to be divided. The loan gets paid by Jimmy Duffin, however that happens, but it wasn't secured. It wasn't properly secured, and that's really important. They never filed this loan. It was never filed with the county recorder, and so it doesn't attach to real property. And what we end with, Your Honors, is where I started. This is a situation where all of the evidence suggests that this is a duck, and in the distance, all you can hear is quack, quack, quack. Thank you, Your Honors.
All right. Thank you, Mr. Hinkins. Mr. Olson, back to you for rebuttal, but only on the cross appeal.
Yes, I understand, Your Honor. I will be very brief. I might not even use all the allotment of my time, so you guys will probably be happy about that. I think what Your Honors are maybe concerned about is this preservation and whether or not it was preserved or not for the attorney's fees. And you've heard my arguments on why I do believe it's preserved. Number one, they did file the post-trial motion to object specifically to the law. Again, we weren't challenging the factual findings. The findings were clear that they accepted the financial declaration of my client and they accepted the expenses of my client. Therefore, he didn't have the ability to pay. Number two, they accepted the expenses of of the opposing party and her income. And again, once you add child support into that analysis, she didn't have a need for attorney's fees. So the evidence that was presented to the court does not justify under the law the award of attorney's fees. The second thing is that Mr. Hinkins keeps arguing is that my client makes 4 times the amount of money of his client does. Again, that's not the analysis under the law. It's not about who makes more money. It's about if there's an ability to pay that money. And so in regards to the preservation rule, I just want to point out 2 things. Number one, there is an exception to the preservation rule, which is if there's an error, if it was obvious, and if it was harmful and the ruling was undermined. Number one, was there an error? Yes.
Did you argue exception to preservation in your initial brief?
I did, Your Honor. I did not actually. I did it in the reply brief.
And we can't consider that, can we?
I don't think you can, but that was an affirmative defense that they brought up. Again, I put in my brief where I believe that it was preserved. And so
we also have case law from about a month ago saying plain error is not a thing in civil cases anymore. So I don't know if you're aware of that.
I was not, because I obviously submitted this brief before that came out. So that's a little bit of a, with all due respects, kind of a gotcha on my client's part, because that's something that's happened subsequent to. So with that new knowledge, my argument to you, honors, today is that it doesn't meet the law. It was preserved. There's no justification with the evidence before the judge that the attorney fees should have been awarded because my client didn't have the ability to pay. Number two, we can't infer and we can't assume what the trial court did. We have the record. There's nothing there's nothing solidly in the record that says, however, I know that his expenses are X amount, but if they go up, his dad's still going to pay them. That's not in the record anywhere. So that's inferring something that's not in the record. All we have are the financial declarations and the incomes of the parties, which clearly establish there's no possible way that my client could pay attorney's fees, and it was an abuse of discretion. It should be remanded for further findings like it was in, I forgot the 2 cases, in Leppert and as well as in Ebhart. So with that, I'll submit, Your Honor. We ask that the trial court affirm Judge Bates on the purposes of the home, and we ask that he reverse or remand for purposes of attorney fees. And I submit there, and I thank you for your time, Your Honors.
Mr. Olson, just to be clear, we in no way think that you should have a crystal ball to know what's coming down the pipe in our cases. And you know,
Well,
it happens. It happened to me personally in practice that I was relying on a precedent. It was a clear winner for me, and the Supreme Court changed their precedent after briefing, and it made for a short and unhappy oral argument.
Well, I guess the benefit to that, Your Honor, is we are still doing this by WebEx. You guys realize I didn't sleep last night, and as soon as Your Honor said that, you couldn't see how red my face went. So I appreciate the candor and the cordiality and the understanding, but no, I was not aware that case just came out. But thank you, Your Honors. Any other questions for me? Okay. Thank you.
Doesn't look like it. Thank you, Mr. Olson, and appreciate the comments by Judge Mortensen. Yeah, that when cases come out a week or 2 before oral argument, it's sometimes hard to know what's out there, and we understand that. So thank you. Mr. Hinkins, can you join us as well for, I guess, the final pleasantries? And we will thank both of you for the arguments that you've made today. Interesting issue raised here in this case, and we appreciate you coming to our virtual courthouse today to help us understand it a little bit better. We'll take the matter under advisement, as we almost always do, and get you a ruling as soon as we are practicably able to do so. Thank you, and enjoy the rest of your day. The court's in recess for a few minutes.
Thanks so much, all of you. Have a great week. Happy St. Patrick's Day.